Well, good morning, good afternoon, good evening, wherever you're joining us from. We're thrilled to have you and thrilled to be able to share your time with the time of our amazing speakers on a subject that really could not be more critical these days: mediation in financial services, problem solving, reflections on 2020, what's new in 2021, and in that context, how can we think about this in some new ways? We could not have a better group of people with whom to discuss this. I'm your humble moderator. I am Elizabeth Stong, a member of the P.R.I.M.E Finance Board, and as you can perhaps infer from the background, a judge, a federal judge here in the United States Bankruptcy Judge sitting in Brooklyn. Our session today is being recorded, and it will be distributed later, including to each and all of you as our attendees. The fact of your continuing participation will be taken as your consent to that recording. Thank you so much. You are muted, my dear attendees. Your video has been turned off. If you have a question or comment, though, we want to hear it, and we invite you to do it. I'm sure you are very familiar with at this point in our Zoom lives together. Put it in the Q&A. We'll be keeping an eye on that, and we'll do our best to get to all your questions. Now, if there's something that requires follow-up afterwards, we'll do our best to do that as well, because we do have your contact information. Your name and your affiliation will help us do a good job in understanding your questions. So please do include that as well, and we'll be keeping an eye on that throughout the session. There's a chat box. You can already see there's some information in it. Please take a look and be sure that you are following that. It will help you know what we think will be helpful to you to learn about some of the things we're talking about, seeing links, things like that. So I think that covers our administrative basis. Let me turn to why you're here, which is a fantastic panel and our topic. We're going to begin with a view from a practitioner and neutral. Jelita Pandjaitan is a partner and the head of the Dispute Resolution Asia practice at the Linklaters firm. And please think kind thoughts in her direction, because it is midnight. In fact, it's now after midnight for Jelita, who's joining us from Singapore. So she's going to give us that forward-looking perspective. What's going to be coming? It's already tomorrow for Jelita, so she'll have that opportunity. Her legal practice and her neutral practice span geography, ranges of disputes. I think if you had to sum it up, you could say if you've got a complicated problem, she's probably someone that you want to look to help you solve it. That's been recognized by lots and lots of organizations, including, just to name a couple, Legal 500 Asia Pacific, which pointed out her extensive expertise in international financial regulatory investigations. She's a member of the Chartered Institute of Arbitrators and is admitted in Hong Kong and Australia, and has proficiency in English and Bahasa Indonesia. That's a new fact for me. After Jelita, we're going to hear from Tony Piazza. And I guess I could just say, you know who he is. Tony is the go-to problem solver in so many ways for so many kinds of problems. It would be impossible adequately or completely to catalog them. He's based in Maui. He practices dispute resolution around the world, and as he urged me to say, because his skill may be exceeded only by his humility, he's done this for a while, maybe decades. And so I would just add this: as I was preparing to do these introductions and moderate this panel, which is an incredible privilege, I have to say, I was struck by the fact that, well, everyone in some kind of private sector capacity hopefully has a commitment to pro bono. Tony's firm may be one of the few that, when you check its pro bono link, what you learn is that they are available and consulted from time to time in matters of regional conflict resolution. It's a pretty impressive credential. So Tony, thank you again for making the time to be with us. And I apologize for going slightly beyond the permitted boundaries of your introduction. Finally, a conversation like this: what's new, what's happening, how do issues of culture come into the picture, would not be complete, I think, without a really thoughtful academic perspective. And we're lucky to have maybe one of the best practitioners and academics who could speak to this issue on our panel as well. I'm going to begin the introduction again the same way, my friend and My colleague, we first met as UNSA trial delegates, Katerina Yiannibas, who teaches on 2 continents, here in North America, here in New York City at Columbia University Law School, where she teaches the negotiation and advanced cultural perspectives on negotiation seminar, and at the University of Deusto in San Sebastian, Spain, where she is associate professor and teaches in substantially the same area, though of course in a different language. She does a lot of research and policy work in designing conflict management systems, and this has extended not only to what you think of as conventional private sector dispute resolution, but also in some new and some different sectors, including human rights in business, where she had a significant role in the arbitration scheme that has been put together to consider effective and productive paths to resolution in that area. But and there's more, but if I go there, we'll have no time for what's most important, which is, again, the substance. Let's start with Jelita. Good evening, good morning. Thank you again for joining us from Singapore. We'd love to get your practice perspective on where we've been, where we're going. You represent a lot of the world's biggest, toughest, maybe, financial institutions. Do you see that your clients are coming around to the idea of mediation? When do you suggest it? Are there still obstacles? Tell us your perspective. Thank you, Jelita.
Thanks, Judge. And thank you for the kind introduction. I think it's fair to say that financial institution clients have been slower to adopt mediation as a standard sort of dispute resolution tool for their situations than maybe corporate clients in other sectors, perhaps energy or technology. It seems to have been more common and more commonly adopted. And why is that? I think there is a tendency in the financial institution space to adopt something of a win-lose, right-wrong mentality in relation to disputes with counterparties or perhaps even customers. And then the other tendency, which I think particularly afflicts the financial space, is a tendency to run the numbers on a dispute. So every financial institution client that I advise insists that I provide them with a prospect of success measure as a percentage of their chances. And invariably, I know that they're multiplying that number by the amount at stake, even though we all know that isn't how litigation plays out. Completely the wrong formula. But these sorts of things tend to prevent people from being willing to engage in a mediated process that's a little more sort of nuanced, I guess. And there can also, I think, carrying on with that sort of numbers theme, be a bit of an over-reliance on the numerical analysis of the case in terms of the actual, the numbers involved in the claim, and maybe an underappreciation that there could be a wide range of sort of methodologies or valuations brought to those numbers, and also perhaps a wide range of perceptions about the behavior of the parties on both sides, which can come out, as we all know, in the trial process. I think financial institutions sometimes find the process of mediation somewhat intimidating. If we think about, the strength of an institution and the sort of identity that it may have versus the counterparty or the customer, there's definitely a leveling that happens in the mediation process. And maybe there's a reluctance also to enter into that kind of space when there's a perception that you already hold maybe the higher ground or the stronger ground. I'm sure both Katerina and Tony have views on how that mindset can be adjusted in the process. In terms of when clients would be more interested in considering mediation and when I advise them to think about it, certainly if there's time and cost pressures, that's one. The second is, I think there is more realization these days that there may be a relationship at stake. Given the scale of some counterparties as clients of banks, it's important to see whether there may be more work available to do with the same client if a matter can be resolved sensibly. And then I think we all know in the day and age of social media how important reputation is and how quickly reputation can be impaired even by matters that come out in a trial process in the public domain, even if the bank ultimately wins in that process, and sometimes particularly if they win. So the privacy of the settlement process can, of course, be a real attraction in recommending that.
The dynamic of suggesting mediation to a client is something that takes me back to my practice days, which still outnumber my days on the bench, about 20 years in practice, now 17 as a judge. it's interesting how it became a different matter to suggest mediation to parties once my first name was Judge. And I think it's an opportunity, actually, I would encourage any jurist, any party, any attendee who's in that role to think about whether it should just be a standard question to ask, because it rests so much more lightly on our shoulders than it does on the advocate's shoulders, just to put that question out there. Now, you head the Asian dispute resolution practice at a global firm. You've got a global practice, but you're based in Asia. Is there a uniquely Asian perspective to these kinds of things, or not so much in these global days? What do you think?
You're right. I mean, I think there's a great internationalization of the practice of all law and dispute resolution. I'm always, of course, very reluctant, and I think it's dangerous to generalize, especially about a region which is as diverse as Asia, both in terms of development and cultures and languages and forms of interaction. I think, after a decade and a half in the region, I would say it's possible to advance something like an average and say that clients in North and Southeast Asia, where I've mostly practiced, are probably slower to initiate a formal dispute process than I think my colleagues in the US or Europe experience with their clients. But I don't necessarily think that it's more likely that they would use mediation to avoid that formal dispute process. What I see much more often is settlement by negotiation. So maybe less that there's a particularly a kind of instinct towards mediation as a process in Asia than in other places of the world. And as I say, I think it's on the rise here as much as it is in other places. I do think, though, that there are some particular considerations that are relevant when engaging in mediation with clients in Asia. One actually connects a little bit to what you just mentioned, Judge, which is it's quite important to emphasize with clients in Asia that the mediator is a facilitating role and not the adjudicator of the dispute. And that is something I always seek to make very clear with parties as they come into the room. There can be a real misperception about that, especially in civil law jurisdictions in Asia. Actually, aside from just suggesting mediation, it can be quite common for the trial judge to conduct the mediation alongside their role as the trial judge. And I think for common lawyers, and even on your own face, Judge, it's clear that can be quite a surprising concept and perhaps not a very comfortable concept. And so it's important to help clients realize that isn't a possibility in the formal sort of mediation process. And then I think finally, I suppose there are always cross-cultural elements. I typically am engaged in disputes that cover cross borders. And so just ensuring, how people are likely to experience the process of coming perhaps to another third location or to the other side location and entering a room, all the things about the dynamic that you create in the room. And then specifically in Asia, because there are so many languages in this region, managing language barriers is one that I'm always very conscious of and spend some time to ensure will be covered by both sides. In my experience, mediation it's a highly discursive process, isn't it? And can be quite an expressive process as well. And in order for there to be a level of trust and relationship created in that room, it's very important for all those who are engaged in resolving the dispute to fully understand everything that's being said about the process as it goes on. So that's something I also particularly focus on.
Wonderful points. And I have to say, as I sit in one of the most diverse districts in the United States, the Eastern District of New York, I couldn't agree more that language and communication and even phraseology can be fundamental to not only good communication, but also establishing a baseline of respect that you may win, you may lose. If it's a judge making a decision, you may persuade, you may not, but never without the context that what you're saying, that it's important to understand what you're saying in every dimension and to communicate the deepest respect for what is your perspective on a situation. So thinking about how things have changed, of course, it's already tomorrow in Singapore, but we've come through quite a year. And I guess what I'd like to know is, when you think about 2020 and dispute resolution, and especially mediation, do you think it's been a good year? Do you think it's been a productive year? What stands out?
So I'm not going to talk about COVID to start with, at least. But I think while many of us were worried about whether our Zoom calls would work, mediation has actually made some quite impressive advances in the past year. Two probably key areas from my perspective. The first is really around the legal infrastructure for mediation. So the Singapore Convention on Mediation, of which we're all very proud, entered into force in September last year, so in 2020. And earlier in the year, in February, Singapore had been one of the earliest jurisdictions to implement the convention into local law as well. And for those who've been busy during 2020 and didn't pick it up, the convention provides for the cross-border enforcement of settlement agreements that come out of the mediation of international commercial disputes in a very similar way to the operation of the New York Convention to implement and enforce arbitral awards on a cross-border basis for commercial disputes. And so I really think that's quite a leap forward for mediation in being as attractive, or at least approaching the attractiveness of arbitration, for which cross-border enforcement is always a very oft-cited advantage. And then I think the other trend is around the institutionalization of mediation. So most mediation is engaged privately. People ring up Tony and his team, and they ask him to help them sort out their dispute. But both the ICC and the Singapore International Mediation Centre last year reported significantly increased numbers of referrals for conducting mediation. And my sense is that there is a growing utilization of institutions for these purposes. And if I can come back to COVID for just one moment, one interesting initiative from two international institutions here in Asia, the Japan IMC and the Singapore IMC, got together and issued a protocol during 2020 because of COVID, such that it was possible then to file a mediation request in either of their centres, and an online mediation would be set up with one mediator in each location. And the mediator at the Japanese end would be able to speak Japanese. And so there would be a sort of cross-linguistic, cross-border, cross-cultural arrangement for potentially for the resolution of commercial disputes in Asia, which I thought was a good initiative and a novel option when everyone was otherwise being forced into this into the online space.
This is going to be one of our big questions, I think, as we come into whatever the new normal, whatever the next phase is. What do we hold on to, and what do we move on from? It's a huge question. All right, lightning round. My last question for you: is this a yes, no, maybe so? Are your clients, as of now, as of May 6th, 2021, you perceive them to be more or less willing to consider mediation in complex financial disputes, or is it hard to generalize?
I would say yes. I think definitely yes at this stage.
Good. I'm liking yes. Yes.
In a time of economic uncertainty, time and cost savings just become more important. Everybody knows that uncertainty is value destructive. If you don't know when you can get your matter resolved, and while the claim is hanging over you, whether claimant or defendant, it creates uncertainty. That makes it more difficult to raise finance, secure investment, and so on. And also, there's even the prospect that the other side goes belly up while you're waiting to get your trial done. So look, I think for those perspectives, practicality is certainly driving more enthusiasm for mediation. And those who've been reticent around virtual mediation, whose concerns will soon be laid to rest, I know, by Tony, are, I think, also just accepting the practicalities of life, which is it will be very difficult to arrange to co-locate for cross-border mediations for some time to come. And so we'll all just have to get used to the screen.
All right, Tony, all this puts one question in my mind. We've heard the pros and cons. We've all been through the last now more than 12 months. Lots of tools in the toolkit. Why bother with this one? Why bother with mediation for a complex financial dispute?
There is no good reason to.
No, there are multiple good reasons too.
No, assuming that one's preference is to have business decisions made by someone else for you, and assuming that you are perfectly content with the time, the duration, and the collateral risks of going through arbitration or litigation.
Ouch.
But if, like me, you like making decisions for yourself and you'd like to be having a clear sense of your options and your risks before you make those decisions, then there are three things about the mediation process that I would find attractive. First, you get a chance to get a more objective sense of your risks than the most diligently pursued adversarial process can provide, because an adversarial process inherently is reactive and it tends to skew objectivity. So in mediation, you have a chance to hear from someone who could as easily be your judge or your arbitrator, how the risks look from the outside. And you can then incorporate that into your own, even if you're doing a percentage prospects of success analysis. It gives you a slightly more objective data set to feed into that process. So that's point number one. Point number two, you have the chance to consider options for resolution without any concern that you may end up bidding against yourself or setting some new floor or ceiling on any future discussions. That's a really critical part of the process. In caucus with a mediator, you can discuss any number of options without putting yourself on the table for anything to the other side. And ultimately, you will never have to put yourself on the table for anything, because we don't use a model of just carrying offers and demands back and forth. You stay in dialogue with the mediator until the point where you could give the nod to a particular settlement option. And then the mediator finds out whether that's possible by advancing a proposal from the mediator to both or all of the parties. And no one therefore ends up at risk of hanging out there with some offer or demand. So that's the second point. After you've had a chance to get a realistic sense of your risks, you have a chance to start discussing realistic options without concern that you may end up bidding against yourself. And the last point is, even if a comprehensive resolution remains elusive at the end of the day, you can give thought to implementing some customization of the, for example, arbitral process. I had a case just last week where the parties came in $173 million apart in terms of their settlement valuations. By the end of a longish day, it was down to a mere $10 million gap, but that $10 million gap was seeming intractable. So the parties decided, instead of going back to stage one and going through with their 10-day scheduled arbitration, they decided to simply bet that delta in their settlement positions, wager that 10 million on a single issue that they agreed would stand as proxy for the manifold issues that they were disputing, and reduce the arbitration down to a one-day arbitration just on that issue, with the undisclosed settlement agreement that is undisclosed to the arbitrator being that whoever prevails on that issue, their settlement number prevails. So that's just an instance of the kind of options that you can have, options that really just don't tend to surface in direct negotiations, and have an evaluation of that done with the highest quality data set in terms of risks and options.
So many sophisticated financial participants, the kinds of clients that Jelita was describing, and many business people assess themselves at being very good at assessing risk, and they're going to want to know about results. Does it work? And what is the track record for mediation in this kind of a process?
Well, we are now in year 42 of what I guess has been a long-term study about how mediation works in different sectors. And drawing on that as our database, the track record for settlement of financial disputes is roughly 8 or 9 out of 10. And that's now proved true over the course of time. So
that's a pretty good statistic. And you're describing a substantial data set and period of time. Is it fairly consistent, do you think? I mean, this has been a pretty interesting 40 years in the world of financial services and financial products, and in the globalization of the kinds of businesses that those participants are involved in. You think it's changed over time? You see that?
No, Actually, I would speculate that it would have, but in terms of the actual database, if you broke it down year by year, you'd find that same 8 or 9 out of 10. And interestingly, that doesn't vary by sector. It doesn't seem to vary by the complexity of the dispute, the magnitude of the sums that are in dispute, the number of the parties. The process seems to be fairly agnostic in terms of input output.
So this picks up on a issue that's been identified in the Q&A by one of our questioners. Thank you for the question. Could you reflect a little more on how the nature of the dispute, anything from a default on a loan to a derivatives dispute to a multi-party intercreditor fight, the kind of thing that frankly might come up in my court, does it make a difference in the track record or in the approach that the parties or the neutral should be taking?
In my experience, the first two do not. The third does, because the third, when you've got a great multitude of parties, implicates a critical factor for any mediation that's going to be successful, and that is that you have personally, directly participating the parties who have both the authority to bind and meaningful discretion in terms of that to which you are going to be bound. And when you have, for example, a multitude of parties, even if you've got a creditors committee in bankruptcy, you have to be darn sure that they really do have both authority and discretion. And that's a prerequisite, but then it also definitely ripples into what your batting average is going to end up being. The more parties, the more diffuse the decision making, and the lower the success rate is likely to be.
All right. I want to focus on that 10 to 20%, the other side of the 80 to 90%. Do you see any commonalities in that group, the cases for which the process is not ultimately successful?
Yeah, the first, second, and third cause of failed mediations are all the same. And it's not having someone personally present in the process who has both authority and discretion. Far too often people come, and it's understandable if you're dealing with large corporate entities, people come and they say, I've got authority. What they don't say is I have authority to act within the parameters that we've already discussed, socialized, and become comfortable with internally, and not a jot further because I'd be putting my job at risk. Well, perforce, if parties come in and they're tens of millions, hundreds of millions, or billions of dollars apart, and no one has the discretion to move beyond that which they've previously been comfortable with, then you have a recipe for failure. So out of that 10 to 20%, 90% is probably accounted for by simply not having someone who is able to really engage in the chemistry of the process, look meaningfully at a new data set, have the ability to consider options that might be a little bit outside the box that have been discussed internally. That's the main reason. Beyond that, it's when you get down to it, there are some cases that really, can't or shouldn't settle, where really the imprimatur of a third-party arbitrator or a judge is important on a lot of levels, politically, being able to sell it with constituents, whatever else. So I'm not of the mindset that every case that comes in really should settle, and if it hasn't, then something has gone awry in the process. True, I childishly still beat myself up for not having done a good enough job, but in terms of the process parameters, no, I don't think that any are implicated.
It's so interesting to me as someone who thinks about process because it's what courts do, and of course substance because it's what we decide. The idea that a process misstep would be a reason for a case not to have an opportunity to reach a consensual and therefore I would say definitionally successful outcome is a challenge. And I assume that lots of work is done in advance by yourself and by anyone else in the world of mediation to know who's coming and to have a sense of what their authority is, but I guess you can't be sure. Is that right?
Unfortunately, yes. We found we put it in bold print type and the exclamation points after it. And it doesn't seem to vary the number of occasions where people come without meaningful discussion.
So we've all moved to Zoom, at least we've moved to video platforms for so much of our work in the last year. What do you think we've learned from that?
Well, one interesting thing I've learned, had you asked me in February of 2020 what I thought the chances were for really successful Zoom mediations, I would have told you with great confidence and completely erroneously that I thought, nah, you really need the face-to-face time. You need people to have traveled in some instances to demonstrate their commitment to the process, and conversely, make it less likely they're going to walk at some point because it's a long walk back to wherever they came from. And I was simply
Especially
wrong.
if they've come to see you in Maui, just saying.
Not an unpleasant walk then back. But I was simply wrong. To my surprise, the success rate, at least measured by the metric of settlements, is slightly higher now over Zoom than it was. Now, why that is, I could only speculate. Perhaps it's because on the topic of authority and discretion, getting top business managers to spend, a couple, 3 days to fly from Frankfurt or Singapore or somewhere else to San Francisco, that's a big ask. So maybe we're just getting better direct participation when people, it's just a matter of, turning on their computer and spending some time in their office or in their home. It may be that people almost perversely, anti-intuitively, feel more secure in their personal space and are therefore more willing to listen and more willing to open up, which is certainly useful in the process. I think I might have underestimated how challenging it is to have someone sitting face to face with you, spending some quality time, telling you things you don't want to hear about your risks or options. And so maybe it's just the communication is actually enhanced by having a little bit more distance. But that's speculation.
Easier to listen fully when you're not in the same room. That is counterintuitive, but I see indications of that in different things that have occurred in our court processes. Maybe like you say, maybe a bit of a surprise. One of the subjects that we want to be sure fully to cover in this program, as much as you can cover anything fully in an hour-long program, is the question of cultural differences. And culture can exist in a lot of dimensions, I think. There are cultures within the business community that have nothing to do with language and nationality and part of the world and everything else that we traditionally think of as culture. There's cultures within sectors. I know this from my years in practice and from what I see in the courtroom in different communities. Just ask anyone about commercial real estate in New York City, and you'll hear about the culture of one area of practice. It's lots and lots of ways to think about it. But how do you, taking it in all the different ways it could be relevant to a mediation type of process, how do you, what guidance can you give from your experience in terms of accommodating and working with cultural differences, and can they even maybe enhance a process if you're able successfully to bring them into the picture? I'd love to know what your experience has been.
I'm going to defer to our resident expert, Katerina, in terms of how that should occur. I do the best I can when you're working with truly internationally. One can't pretend, at least this one can't pretend to really have even a cognition, let alone a sensitivity, let alone a skill in dealing with manifold cultural differences. So I try to be as present and respectful as possible. That was your point, and I think it's critically important. I assume, and generally correctly, that people who are willing to invest in a mediation have also invested in translation services to the extent that's critical. So I don't have to pillory my poor linguistic abilities. And beyond that, I'm much more interested in hearing from Katerina how those kind of things should be held in our minds and hearts and then implemented in our practices.
That is a perfect segue to our next speaker, Katerina Yiannibas, who thinks and writes and teaches about these subjects. Your reference to translation reminds me of something I learned in the setting that Katerina and I first met as NGO delegates to UNCITRAL, where everything that happens is interpreted simultaneously into, I believe, 7 official languages. An extraordinary undertaking. It happens in the documentation, it happens in the interventions and the presentations. And I learned from that experience, including from the interpreters, extraordinary people, extraordinary talented people, that there is a difference between translation, which is what Google Translate can do for you, and interpretation, which is not only the words, but also the meaning. And when I think about interpretation, I think about interpreting a legal system, interpreting a culture, interpreting a dispute, helping one participant in a process literally sit in the chair and wear the shoes of another participant in the process through an interpretation. Katerina, thank you again for joining us. We need now to have your perspective and context on all of these issues. And from that cultural perspective, maybe we'll start with the idea of trust. I think you heard pieces of that in each of what Jelita and Tony had to say. Tell us about how this looks from all the perspectives you have, including on 2 continents, the Academy. Over to Katerina.
Yeah, thank you, Judge, and thank you to Tony and Jelita. Listening to you, a couple of things really stood out, and I love that you mentioned language. I think that's something critically to think about, and as the judge mentioned, I cannot emphasize how much I've been thinking about trust over the events of the past year. So that's going to really feature in some of my thoughts today, namely because, and going to what Tony said, I just try to be aware, I do the best I can. That's really the most you can do, is bring a certain amount of awareness to the fact, and these are questions that go usually unanswered because we're on autopilot. This is my dispute settlement clause, this is my choice of law, this is what the contract said, and therefore it is legitimate. And you really have to bring some critical analysis to those choices. Ultimately, your choice of forum, your choice of law is a choice about cultural preference. And it needs to be understood as a choice of cultural preference. I think the judge referenced this in her remarks. Systems of law are really systems about value. The same way there is no consistent international law that binds all aspects of our life, when we really kind of bring that down to the ground, you're really making choices about what people value, what's important. And so even just the choice of law, the type of process that you choose, you're making a preference about how certain people see the world over how other people see the world. You're making choices about dominant worldview as well. And there needs to be a little bit more awareness about that. Ultimately, there has to be some amount of crystallization of the idea that not all problem-solving mechanisms promote trust for all people everywhere. And if you really take that to heart, we need to be making much more holistic and inclusive decisions about some of these choices. The operationalization of trust is culturally specific. So what works in one place may not work somewhere else. What works with a certain type of dispute or a certain type of party may not work for somewhere else.
And it makes me think about, again, a common experience that anyone in a decision-oriented dispute resolution process encounters regularly, which is trust in what? Is it trust in your adversary? That may be a hard sell. Is it trust in your negotiating partner? That's a shift of nomenclature, and maybe a shift of more than that. Is it trust in the process? I don't think many people who've been cross-examined aggressively come out of it thinking, I really trust that lawyer to ask me a fair-minded and balanced question. The question, of course, needs to be fair in a legal sense, but if they aren't having a trust in the process, then the process isn't going to work. But trust in what, I think, is a very interesting thing. And in an American or Western or common law style system, we probably have a baseline sense that the trust should be in the transparency and the credibility of the process at a minimum. And then the rest comes as the mediator, the advocate, the arbitrator maybe gets more involved in the particular dispute and brings it forward. Back to you.
Yeah, no, I think that's a really important distinction. You don't trust the adversary because there's conflict. So as much as possible, if the conflict resolution process can promote trust, then the process will be deemed more legitimate by the parties, and then the solution will be deemed more legitimate. If the process is not deemed legitimate, if the process doesn't enhance trust of the parties, then there's a high chance that the result will not be deemed as legitimate, which is why in cross-border litigation, we have issues of recognition and enforcement. That in and of itself is saying that there's less trust in the legitimacy of the process. So if you're looking for, and from my understandings working, I teach also in the business school, and so I've learned a lot from the business community because that's another culture as well. The language of business is not process. The language of business is trust and relationship. I recently drafted a case from my class, and I was like, I want this to be about dollars and cents. I want my students to do a distributive negotiation. I want to know what the cost would be and if there was a delay, and help me, speaking with someone, a coffee importer out of Dubai. And I was like, if you want to do business in Uganda, we came up with this beautiful case about specialty coffee. I was like, dollars and cents, dollars and cents. And said, Katerina, I don't think you get it. Sure, dollars and cents, but I would pay $1 over or dollars over price on the pound if I have a good relationship with the supplier. He's like, it's never just dollars and cents. And so as you think about relationship in a global business context, then you want to think about what processes can build relationship. And when you think of that, then how do you do that in a process? You want to look for processes that promote curiosity, promote listening, promote learning. No offense, Judge, that is, I know in your courtroom that happens, but not in courtrooms all over the world, right? Processes that really promote collaborative settlement, like mediation, facilitated dialogue, negotiation, that's where you learn a little bit more. And when you have these enhanced asymmetries between cultures, then these are processes where you can really learn about the other party and build relationship, more so than an adversarial process where you have a winner and a loser. And then to that point, Jelita mentioned these processes, these simultaneous processes about language. That's fundamentally important. The minute you make a judicial choice about forum, you're making a choice about language. And we all know official translations cost money. It also means that you need local counsel who may not speak your language. It means that will be a perhaps less trusted advisor. You're making a lot of choices that really enhance lack of trust, in fact. So on the language point, and it's like the eternal teacher in me. I'm like, another anecdote from class, but I think there's really, classroom for me is these laboratory experiments where you can really see some of these points in action. Because in the real world, right, we want to save face. We're not going to say how uncomfortable we feel doing things or how comfortable or the psychological effect that some of these processes have, right? We're professional lawyers, but students will tell you, students will tell you the truth. So I tested this language experiment in class. I give a simple negotiation to my students. I have students from all over the world, and I group them on their native language. And it's a very simple negotiation. We all know the facts, and they set out all speaking in English. This is some of these courses are taught in English. And then some way through, I ask them to switch to their native language. And what happens, and I have people observing and people negotiating. And then afterwards, we ask what we observed. And it's like a light turns on. All of a sudden, people will start speaking quicker. Their faces light up. It's almost like something has changed. And if I could describe it as trust, just the dial just goes way up. And then after we talk about this and they say, oh, well, now for sure, I'll always use a translation service, or now I'll always have someone who speaks that language on my team, or if I speak that language, I'll try my best. And I said, okay, sure. So maybe you can speak a language and all of a sudden there's more trust. What about all the things you can't change at a table? How much exclusion does it create not being in your native, either not just culture, but language? When you take that comfort away, how does that feel? And what happens when you can't change language and your gender doesn't change, or your race, or your ethnic group? How about that in terms of exclusion and process and the trust issues that drives? Are we thinking about that when we're engaging people in their most vulnerable moments of conflict and then expecting to conduct business for the next 10, 20, 30 years? So just some thoughts on that.
Well, I want to take a couple of those examples and circle back to Jelita, because I can imagine in the geography where you where you do your work and will stay with your role as advocate as opposed to neutral for the purposes of this. And having spent a little time in the region myself, I can imagine there may be situations, you tell me if I'm wrong, where a conversation is going on in English as maybe a dominant second language of every participant, but then there are sidebars going on in different languages which are not widely understood. And I guess my question would be, if you see that happening, first of all, does it happen? And second, how is that something that you think you can work with? I'll then have a similar, the same question for Tony. And I note that both of you were smiling and nodding as Katerina was speaking. Jelita, does any of this ring a bell to you?
Very much so, Judge. One thing that sometimes happens, particularly in the private bank environment, private bank dispute environment, is suggestions from various people involved in the process, let me put it that way, that some people don't understand any English and therefore perhaps didn't understand a financial product in the process of a transaction, and then you may end up with conversations happening in the room in English, and it's quite clear that other people in the room who said that they were not conversant in English and therefore have translators available to them are nevertheless well and truly comprehending what's going on in the English language as well. So there can be even distrust or mistrust about which languages people are capable of conversing in the room. So I agree, it's an issue. Generally speaking, one thing that I think is extremely important for the creation of trust is the opportunity for those who are frontline, in the sense of the core actors in the dispute, to be able to say something at some stage of the process, usually in the plenary open. And I know Tony has his own process. Certainly the ones that I've typically attended, there's an opportunity for that sort of position expression, and it's not just the advocates or the representatives setting out the kind of hardcore line of the debate, but rather the opportunity for people to at least two people, one on each side, to express what they genuinely believe the dispute is about from a non-legal perspective. And I always encourage that is done, of course, in a person's native language, because then they are most often able to convey the emotion and the true meaning to them of the issues. And people may be thinking, as I say that I'm talking about the bank customer, but I'm also talking about the institution, because the institution has always participated in the creation of the problem, one way or the other, and not because they're necessarily at fault, but they have been a party to the situation which has led to the dispute. And it's someone in the institution who's been part of that. Maybe it's a relationship manager, or the deal maker, or some other, the trader or the broker, but someone has been there. And for that person to be brought forward and to express what the dispute is really about is in my experience typically quite powerful, and it's very important that it happens in a person's native language.
It's such an important set of points. You're reminding me of the dynamic with a big Wall Street type of dispute. Often I would represent a defendant, and the business person whose P&L would be affected if there was a settlement or a judgment was a critical piece of any picture, but also maybe a complex piece of any picture, and language, whether it's literally one language or another, one dialect or another, or one business mode. Katerina mentions teaching at the business school, teaching at the law school, and those differences. I know from mediations that I've conducted for my colleagues, other judges in our court, which is fundamentally a problem-solving and a forward-looking court, along with all of its other duties, since we do work with the restructuring and reorganizations of companies. Seeing the balance between the kind of thing that in a court hearing on the record, it would be very hard to accommodate. I need you to speak to each other in whatever way is most effective for you. That doesn't make a very good court record on the record. Tony, how do you think about these things in your role, especially at the beginning of a mediation?
There is so much to unpack here. Would that I had the knowledge and the skill to do it. But if you only looked at the line item of language, my linguistic abilities are so meager, even in English, that to pretend to extend them meaningfully across other languages, it would be farcical. Then you get into the whole penumbra of cultural issues that would also impact the process. So what I do by default is I just put my trust in the belief that there is one universal language of trust, and that the doorway to it, you have to demonstrate. You can't think your way to it. You can't engage in active listening and somehow project your way through it. People of whatever language or culture I've come to experience are very finely tuned to manipulation. And so if you really want to have trust, and it is critical to the mediation process, you got to put yourself on the line and demonstrate that you're trustworthy. Every minute, including the minutes when my frontal brain is trying to back up and analyze and decide what should I do next, and to kind of tether it back down and actually be present with people. So you're showing respect, not just by showing respect. You're showing respect by feeling it, acting it. And that's the only way I can even try to accommodate that kind of diverse spectrum of really critically important things.
So is that easier in a remote proceeding, harder, or just different?
Well, on the belief that when I am actually doing it, that it tends to be reciprocated because people are pretty responsive to feeling trust. I can tell you I've been seeing it again, surprisingly earlier, more often, seeing the signs of it in mediation. I had one dispute with a person who had been belatedly determined to be wrongfully incarcerated, belatedly by the measure of over 20 years, and now had a contrance to work out with the government entity that had caused that to happen. One might think that after 20 years in prison, one would be kind of sensitive about prematurely trusting someone on any level. But that gentleman, fairly early in the process, just stopped at one point and said, "John, I trust you. What do you think we should do next?" And I was flummoxed. I really actually stopped and said, "How could you do that? You don't know me from Adam." So somehow the process doesn't seem to attenuate the opportunity for demonstrating and then receiving reciprocally trust.
One of the things I've discovered, and I've been doing remote video hearings for months now, but I for some reason this only dawned on me, I think this week. I'm not used to seeing myself when I'm on the bench. You're not used to seeing yourself, Tony, when you hold a mediation. Katerina doesn't see herself when she teaches. Jelita doesn't see herself when she meets with the client, right? We don't walk around with mirrors. We have images of how we look. I've discovered I probably need to be a little tidier with my jacket and robe. But how do you, does that make a difference? Does the fact that we're all looking at each other all the time make a difference? And if so, is it a good difference or bad difference?
Jelita,
Jelita, what do you think?
I was going to say Katerina must have a perspective on that.
All right, Katerina, what do you think?
Than my gut reaction to it. I certainly am. When I act as an arbitrator, actually, I'm more conscious now of, and so similar to the. I mean, not obviously in any way equivalent to the role you play a judge, but that sense of
no, but not so different either. You're a decision maker. The parties know that
they
could lose.
Continuous attitude projected on my face. So I do very much notice how I might be appearing while listening, actually, and how whether that is building both trust and respect with the parties who have asked me to help resolve their dispute. So I think having the camera there is quite helpful.
It does keep you mindful of something, right, Katerina? What do you think? How did it play out for you in the last year?
Yeah, I agree with Jelita's point that it's definitely an opportunity to see your reactions to listening, and for others as well. And because usually when you listen, you are watching one person, but this gives us a tremendous opportunity to watch 10 people and still be intently listening to one. So for my own team, when I do some of my anti-racism work, I'll tell people, you're showing too much agreement or not enough agreement. You need to be more stoic. And I can give that note while still fully listening to one person. So that's incredible. The other part that I think is really interesting, this was mentioned a bit earlier, is we're all these, like 3 centimeter by 2 centimeter boxes. So there's a tremendous leveling device. I'm quite tall. So when I come into a room, and oftentimes I will purposefully wear 3 to 4 inch heels and just tower because it's more physically intimidating. That's gone. I am now so you all don't know that Judge Stong is a powerhouse, not as tall as I am, but here we are. We look effectively the same. That's a tremendous leveling device. It takes away a lot of physical intimidation.
5'3" in a good day. But there's something about that robe that seems to make up for a little bit of that. It is, when you go through life, I've said this for decades, when you go through life, 5'3" and female, you better assume you're not going to be physically intimidating to many grown-ups, I guess. It still works on the playground, maybe. Tony, thoughts on this?
I just have the unsettling reality that while in my mind's eye, I continue to be Luke Skywalker. I'm sorry, the cultural reference here I'm demonstrating is going to be lost on some of the attendees. But
Luke is pretty global, I think.
But I see myself on screen and I realize that without having paused at Obi-Wan Kenobi, I've become Yoda.
Yes. Well, people do listen pretty intently to Yoda. I'll just say that. We have a terrific question in the Q&A that I want to get your quick thoughts on as I see that we are approaching the end of our time. You've each said or suggested that mediation at the highest end, and I say this as someone who knows to her core that every dispute is important from the perspective of the parties, but at the highest end, the most complex, maybe the most figures to the left of that decimal point, whether they're euros or dollars, whether they're Singapore or US dollars, whatever, that mediation is increasingly attractive and should be viewed as increasingly available as a problem-solving tool. Why? Why do you think that is? And you've only got about a minute to tell me, each of you.
Jelita.
Tony?
Can I lateral to Jelita on this?
Jelita.
So I think I mentioned a couple of possible theories earlier on around time and cost savings. I mean, I genuinely think even in good times, arbitration and litigation, which have both been very popular dispute resolution methods, are seen as costly and drawn out. And in the kind of pure financial context, sometimes that just isn't an appropriate trade. So better off to deal with the prospect of making some concessions in the course of a mediation, but closing out the risk early. So I that's one of the main reasons I think that it has become more attractive as an option. And then the other one I think actually is privacy and reputational risk is associated with having these kinds of disputes, because financial institutions have also been slower to come to arbitration as a standard form of dispute resolution, and so they have less often made provision for their issues to be resolved in private, and so mediation provides that opportunity as well, I think.
So are there culture shift issues here, Katerina?
I think so. I think that in a cross-border context, and I'm being very deliberate by saying cross-border context, I think that mediation is a more appropriate mechanism, or other neutral-like mechanisms where you're able to have a movable feast and you can remove certain biases from the process, particularly around the forum, domestic jurisdiction and laws and processes. I think you're able to introduce more cultural sensitivity when you remove some of the national bias that's inherent in a judicial process.
How would you persuade a hard-nosed CFO that something that uses the phrase cultural sensitivity would have a role in their analysis of how to resolve a dispute?
I would say, how much value is a 20-year business relationship cost to you? Because this process is most likely going to deliver you that. Is that important to you?
It comes back to Tony's first answer to my first question, I think. But about why bother with mediation. You know what? If you don't care about that sort of thing, yeah, you're right. Why bother? But maybe you should step back, take a deep breath with permission here in a caucus session, and think about maybe there's another way to frame those issues that would be. I say this again as a judge who sits in a problem-solving court, who, kind of comes to work every morning thinking, how do we have a good, transparent process that preserves and creates value for all participants? Of course, using the tools of the legal system that are our foundational tools. All right, I think we're down to final thoughts, final reflections. We have, I think, permission to go into just a minute or two of overtime, and so maybe what I'll do is go in the same order that I did when we first heard from you and when I introduced you, and that will be first stop, then Jelita. Over to Jelita. Final thoughts. Looking back, looking forward.
Yeah, I mean, I think I wanted to just make a very brief point, actually. Tony touched on this earlier on about the possibilities that come from mediation, even if it doesn't result in a settlement immediately and you proceed on to whichever other formal process was in your stars or in your future when you began the mediation process. Comparatively with many other options that are available in the disputes context, mediation is extremely low cost. And so from a perspective, in my view, of kind of risk reward, if that's how you want to analyze it as a financially minded person, and thinking about how much is at stake in the ultimate process, actually there's very little to lose in conducting mediation, because it's a completely without prejudice process. Even if you don't move at all, you come away with more information. But in most cases that I've been involved in, even where we can't reach settlement, as Tony indicated, you can narrow areas of dispute. You can be much more informed about what you really should focus on at trial, if that's where you end up. And of course, there's the upside prospect of actually coming away with a settlement and saving yourself all of the rest of the time and money that's involved in the full process.
One of the things that I sometimes say at the outset is I see people they're in a courtroom, right? I'm wearing a robe, although I'm not the judge in the case, and I'll say, just remember this. Listen to me. Nothing bad happens to you here that you don't agree to. So it's okay. There's really no downside. Tony, same question. Final thoughts.
My only final thought is that was just too lovely a note to let it pass, ending on that. So I'm going to pass. Thank you.
Oh my goodness, Katerina, take us home.
The only final thought I would add, and at the risk of sounding too let's save the world and thank you to world peace, is just simply, I would just invite everyone, as we do the good work of solving problems, to do such with one core value in mind, which is human dignity. And I think that as much as possible, if we could understand what that means from a perspective that isn't drawn out in our own personal identity, but we take a little bit of perspective when we approach some of these systems that are ultimately wrought with emotion and wrought with a lot of shame and fear. As much as possible, try to stay human. Maybe a bit cliche, but I think it's understated in the law far more than it need be.
I think it can well underlie both process and substance. I've never seen a situation that was improved in my practice or my courtroom by treating people poorly. And I have told judges probably in 25 or more countries, I think it's on 5 continents now, that my most effective case management tool, including in the worst situations and the biggest situations, is to treat people better than they've ever been treated in any dispute resolution setting ever. So thank you each. Thank you all. Thank you, our audience. Thank you, our faithful questioners. I'd like now to pass to our fantastic secretariat, Camilla McPherson, and to put on the record my heartfelt thanks, personal thanks, both to the speakers, also good friends, and to our amazing team, which is behind the scenes but deserves to be front and center on the stage, Camilla and Nancy, for making all of this happen. You can imagine the time change issues we had. You can imagine the technology challenges. The fact that this program took place is a huge credit to their skill and also to their persistent. So thank you for that. Camilla, take it away.
Thank you so much. I really appreciate that. So let me also thank all of the panelists for their contribution and Judge Stong for moderating. What an amazing session. It's been a real privilege to be a part of it. Now, this event is the final session in Series 3 of Prime Time. Our virtual program will continue in June, and if you keep an eye on the Prime Finance website, you'll find out more details. I'd like to thank FTI Consulting and Dwarf Financial Technologies for sponsoring this series of Prime Time, and Bertha Capital for sponsoring this particular session. If you're interested in sponsoring a future event, please get in touch. Thank you also to LexisNexis for their support with promotion. Finally, Prime Finance accepts donations through Friends of Prime to support its work. If you'd like to make a donation or to find out more, please contact the Secretariat. Thank you so much, everyone. Goodbye.
Thanks, everybody. Be safe, be well, and send us your thoughts. Take care.